This just in. There are emails that arrive quietly, and then there are emails that slam into your day like someone knocking over a filing cabinet inside your brain. A Pixsy email tends to be the second kind. It comes with a screenshot of your website, a line about unauthorized use, and a payment request large enough to make you briefly question every life choice that led you to owning a small business. The language is formal. The tone is urgent. The implication is very clear. You messed up and now you need to pay before things get worse. Let's slow this right down, because whether you made an honest mistake or triggered an over-enthusiastic copyright detection system, you are not automatically guilty. You have rights, you are allowed to ask questions, and no, paying immediately is not the responsible thing Pixsy would like you to believe it is. This video will explain how Pixsy operates, why their emails feel so threatening, what you should actually do next, and why pushing back calmly is not only allowed, but often necessary. Let's start with what Pixsy actually does. Pixsy is a copyright monitoring platform used by photographers and image creators to track where their work appears online. Using advanced image matching technology, Pixsy scans websites and flags images that appear to be used without permission. When a match is found, Pixsy sends a demand email on behalf of the creator and requests a settlement fee. Pixsy then keeps 50% of whatever is paid. And that last part matters. Pixsy operates on a contingency model. They only make money if you pay. There's no upfront cost to sending demand emails, which means there is very little downside to casting a wide net and seeing who panics. This does not make them automatically dishonest, but it does explain why accuracy often comes second to urgency. So here's why the email feels so intimidating. Pixsy emails are designed to look legal without actually being legal documents. They include deadlines, warnings about escalation, and references to partner attorneys, all carefully chosen to trigger a sense of immediate risk. What they do not say clearly is that Pixsy itself is not a law firm. They cannot issue fines. They cannot declare you guilty. They are requesting a civil settlement, not enforcing a judgment. That difference is crucial, especially for small businesses that assume legal language equals legal authority. Let me tell you about my CopyTrack experience and why it matters here. Before Pixsy became the name filling inboxes, I received a similar email from CopyTrack. They accused my marketing agency of using an image without a license and demanded payments. The tone suggested the matter was already decided. The problem was that I did have a license through Canva Pro. So instead of paying, I responded calmly and asked for proof. I requested confirmation that they were authorized to act for the image owner, clarification on the mismatch between the contributor name and the Canva listing, and compliance with South African law, which requires a proper letter of demand before payment notices. When Canva confirmed my license, I forwarded it and told CopyTrack to take the matter up with Canva directly. The case disappeared. What bothered me was not that the creators wanted protection. It was that the burden of proof landed entirely on me before they demonstrated any right to make a claim. The assumption was guilt first, clarity later, if at all. And Pixsy follows the same playbook. Copyright is serious, and that still matters. I want to be super clear on this. Copyright infringement is not harmless. Creators deserve to be paid for their work. Courts do not ignore unauthorized use, and neither should businesses. But seriousness does not justify bullying. Mistakes happen. Images may have been uploaded years ago. Contractors source visuals incorrectly. Stock licenses are misunderstood. Small businesses do not have legal teams reviewing every blog post image. Most copyright laws recognize this reality. They allow for proportional responses, especially for first-time or low-impact infringements. Pay now or else is rarely how the law is meant to work. Then there is the shortcut nobody talks about. Pixsy emails often accuse small business owners of cutting corners. That's the message between the lines. You used an image without paying a creator. You took a shortcut. You got caught. Now pay up. But here's the part that never gets mentioned. Some of those creators are also taking a shortcut. When photographers license their images through stock platforms like Canva or Adobe Stock, they agree to receive royalties through that system. That platform becomes the channel. When they then work with a company like Pixsy to go after the same images, they are sometimes demanding a second payment from a user who already paid, just not directly to them. This is where the system gets murky. If I use an image legally through Canva Pro and that creator already received their royalty through Canva, what exactly am I paying Pixsy for? It starts to feel less like enforcement and more like double dipping. And then there's the bigger issue. The idea that creators deserve due process when their work is used without permission. Yet, when it comes to collecting fees, many skip due process entirely by outsourcing to enforcement companies who operate with automation, vague language, and urgency over evidence. If creators want to be treated fairly, the same courtesy should extend to the people they're targeting. Because if it's wrong to cut corners when licensing an image, it's also wrong to cut corners when enforcing the law. And here is why location changes everything. Pixsy is based in the United States and represents photographers worldwide. But your legal obligations depend on where you are, not where Pixsy is. In South Africa, for example, foreign claimants may need to post security for costs before suing. First-time non-commercial infringements can attract relatively modest fines. Proper legal procedure matters, and demand emails do not replace it. This is why Pixsy prefers voluntary payments. It avoids jurisdictional complexity and legal friction. They know this. You should too. So here's what not to do first. Before you do anything else, it helps to know what not to do. Most people make mistakes at this stage, not because they're careless, but because the email is designed to rush them into action. So number 1, do not panic pay. Pixsy's email is written to create urgency, but urgency does not equal legality. Their first message is a demand, not a ruling, and paying immediately does not make the situation safer. It simply removes your leverage. Once money has changed hands, it's very difficult to recover it, even if you later discover you had a valid license or the claim was flawed. Number 2, do not ignore the email completely. While panic paying is a mistake, total silence can also work against you. Ignoring Pixsy does not make the claim disappear, and it can trigger escalation to a law partner firm. A short, neutral response acknowledging receipt and stating that you are reviewing the matter is usually enough to slow things down while you investigate properly. Number 3, do not respond emotionally or defensively. It is tempting to fire back an angry reply. Believe me, I wanted to do it too, especially if you believe the claim is unfair. Resist that urge. Emotional language, accusations, or sarcasm can be misinterpreted or later used to suggest bad faith. Keep your tone factual, calm, and professional at all times. You are not writing to win an argument. You are creating a paper trail that protects you. Number 4, do not admit fault prematurely. Phrases like, I'm sorry or I didn't realize may feel polite, but they can read as admissions. At this stage, you are not confirming anything. You are verifying whether the claim is legitimate. You are allowed to do that before accepting responsibility for anything. Number 5, do not assume that deleting the image fixes the issue. Removing the image is sensible and shows good faith, but it does not automatically cancel a claim for past use. Deleting first and asking questions later can also weaken your position if you remove evidence you later need. Save screenshots and records before making changes. Number 6, do not assume Pixsy's calculation is fair or final. The amount requested in the first email is not a legal standard. It is an opening figure. Pixsy often starts high because it anchors the conversation and makes smaller settlements feel reasonable later. Treat the number as negotiable until proven otherwise. Number 7, do not assume their email replaces proper legal process. Pixsy's message may look official, but it is not a court document. In many countries, including South Africa, there are specific procedural steps that must happen before legal action is valid. A payment portal with a countdown timer does not override local law. The goal here is not to dodge responsibility, it's to make sure responsibility is assigned correctly, proportionally, and through the proper channels. That is not avoidance, that is due process. So here's what to do instead. Once you've stopped yourself from reacting out of fear, here's a step-by-step plan that keeps you in control. Step 1, acknowledge the email, calmly and briefly. Reply to Pixsy with a short message that confirms you've received their notice and you're reviewing the matter. This stops the clock emotionally and buys you time to respond. Keep it neutral. Do not admit anything. Do not explain anything. A simple, thank you, I've received this and am reviewing the image source and licensing details. I'll respond shortly is enough. Step 2, create a folder and save everything. Start a digital paper trail. Save their email, your reply, all attachments and screenshots of your website showing the image in context, including the URL and visible date if possible. Also take screenshots of the Pixsy payment portal and anything else that might be relevant later. Step 3, temporarily remove the image from your website. Taking down the image does not admit fault, but it shows good faith. Make a note for your records. Image removed pending verification of license. That phrasing matters. It keeps you neutral while still taking action. Then step 4, search for the original license or download source. Log into your stock photo accounts, check Canva, Adobe Stock, Shutterstock, Envato, or wherever you typically get images. Look through your downloads, invoices, or design files. You can also search email archives or ask your web designer if someone else added the image on your behalf. Most platforms retain license history for years, even if your subscription is ended. Step 5, run a reverse image search. Use Tinai or Google Images to find where else the image appears online. If it shows up on multiple stock sites or blogs, that weakens any claim that Pixsy's client has exclusive rights. It also gives you leads on where the image may have originally come from, in case you're not sure. Step 6, send a formal request for proof. This is where most people give up, but it's also where Pixsy is most likely to back down. Send a professional email requesting proof that their client owns the copyright, so registration or release form. Proof Pixsy is authorized to act on their behalf. Original publication date and source of the image. A breakdown of how they calculated the settlement amount. And confirmation that the image was not licensed to you via a stock platform. You do not need to explain your side yet. This is about shifting the burden of proof back to them, where it belongs. If you do find your license, great, send it. Clearly state that you had a valid license at the time of use and that the matter should be closed. If they have any further questions or issues, they can take it up with the stock image company that issued the license. This should no longer be your problem to deal with. In fact, it should never have been your problem to deal with. And in most cases, that ends it. However, if you did make a mistake, you still have options. Pixsy's initial amount is negotiable. Many businesses settle for far less than the original demand. You can question how they calculated the fee, point out low traffic or limited use, and propose a reasonable licensing amount. If the claim is large or the tone escalates, a short consultation with a copyright lawyer can save you far more than it costs. Here's the bigger pattern. Pixsy is not alone. CopyTrack, PickRights, and similar companies operate in the same way. Automated detection, aggressive emails, inflated opening numbers, and pressure to pay without thinking. This does not make them villains, but it does mean you should not treat their first email as the final word. Be firm, not fearful. Using copyrighted images without permission is not okay. That is not what I'm saying. What is not okay is assuming guilt, skipping due process, and pressuring small businesses into paying fees without proof or proportionality. You are allowed to ask questions. You are allowed to verify claims. You are allowed to protect your business without feeling like a criminal. So be calm, be firm, and be informed. And if you want help writing clear, confident messages that protect your business, download my free 5-minute marketing fix. It will help you write one clear sentence that explains what your business does and why it matters. You can download it for free in the description below, or go to strategicmarketingtribe.com/fix. But what about you? Have you ever received a copyright demand email? I'll go first. Yes, I was contacted by CopyTrack. It wasted a week of my time, even though I hadn't done anything wrong. Okay, your turn. Have you ever been accused of copyright infringement, even when you had a license? Let me know in the comments. I'm Vicky Sidler from the Strategic Marketing Tribe, and I post helpful news updates for small businesses every day.